Dear students, viewers, and the subscribers, welcome to the IAS Mentor. We are going to the day 7 discussion of the Prelims Preparation Mentorship Program. So, today, if you see on the day 7, for the first week, students have prepared certain topics. So, these are the targets on different days. Right from the historical background, preamble, fundamental duties, fundamental rights, DPSP. So every day certain targets were given and every day 10 questions were given. So now on the end of the week, now we are having the first part test for the subject Indian polity. So today we'll be discussing 50 questions and already these 50 questions are given to the students who are part of this particular program. So now we'll see the explanation for these things. So in this way, every week we'll try to cover some substantial thing and then again the consolidation of those things, and when we complete a subjects, we'll have a full test. So this batch has already commenced on 1st December. The second batch is going to commence from 15th of December. Okay, interested students can reach out to the IAS Mentor. Come to question number 1. With reference to the powers of the governor of a state, consider the following statements. Statement 1. The governor may reserve certain state bills for the consideration of the president, even if the Council of Ministers advise otherwise. The governor may reserve certain bills for the consideration of the president. So basically, if you look into the Constitution under Article 200, that reserving bills for the consideration of the president is a discretionary power. So yes, he can do that. The governor is not bound to appoint as chief minister as the leader of the largest party in the legislative assembly when no party has a clear majority. See, the conventional practice is when any party is having the majority, then the leader of the largest party or the leader of largest coalition. When no party is having the majority or the coalition not having the majority, then it is not the convention. So it is basically, then it becomes a situational discretion of the governor. So the governor not bound to appoint. So this is also true. The governor can dismiss a council of ministers even if it still enjoys a majority support in the legislative assembly. The governor cannot dismiss. The governor can dismiss, or we say that the chief minister and the council of ministers hold office during the pleasure of the governor. It comes only when they lose the majority. So therefore, that is not the right answer. Right statement. So which of the statements given above are correct? Statement 1 and 2 only. All right. So come to the next thing. Consider the following statements about the governor of a state. The governor holds office during the pleasure of the president and has no fixed tenure. Yes, under the constitution, the governor has no fixed tenure. A person can be appointed governor for more than one state at the same time. This is also true. This came into existence by the 7th Constitutional Amendment Act in 1956. The governor must be a member of the state legislature at the time of appointment. So not, in fact, it is not necessary. It is not a necessary condition that the governor must be a member of the state legislature. The governor is required to act on the aid and advice of the council of ministers in all circumstances. Under the constitution, the governor has certain discretionary powers, so it is not necessary that he has to act in accordance with the aid and advice in all these circumstances. Okay. So for example, when imposing the president rule, when recommending for imposing president rule under Article 356 or reserving a bill for the consideration of the president, the governor does act on his own. So which of the statements given above are correct? Only statement 1 and 2 is correct. All right. So come to it. So come to the next question. With reference to the pardoning powers of the President of India and the Governor of the state, consider the following statements. Statement 1. Both the President and the Governors can pardon a sentence of death. So it is not the power of both the President and the Governor. So both cannot pardon it. The President power of pardon extends to office against the union laws as well as the court-martial sentence, whereas the Governor powers does not. This is also true, because the governor does not have the power with regard to pardoning death sentence or court-martial. The governor can remit or commute penalties in certain cases arising out of state laws, but cannot exercise his power of offense if it relates to the matter in the union list. This is also true. The governor can remit or commute penalties in cases arising out of state laws, but cannot do in case of what is called as the offences relating to the union list. Both the president and the governor has the pardon death sentence. That is not possible. So the right answer is only option 2 and 3 only. Option B is the right answer. Come to the next thing. With reference to the Vice President of India, consider the following statements. The Vice President is elected by an electoral college consisting of Houses of Parliament, including both Houses of Parliament, including nominated members as well. As for the Vice President, it includes both the members, elected as well as nominated members. A candidate for the office of the Vice President must be qualified for elections as a member of Rajya Sabha. This is also true. This is what the qualification. For the President, he or she should be qualified to be a member of Lok Sabha. For the Vice President, it is Rajya Sabha. The election of Vice President is conducted by proportional representation by means of single transfer vote. So this is also true. And the voting is by secret ballot. So what is the correct answer? It is 1, 2, and 3 only. The correct answer is option D. Come to question number 6. With reference to the constitutional position of the Vice President of India, consider the following statements. When the Vice President acts as President, he enjoys all the powers and immunities of the President but does not perform the functions of the Chairman Rajya Sabha. True. When the Vice President is acting as a President, who acts as the Chairman of Rajya Sabha? The Deputy Chairman of Rajya Sabha acts as the Chairman Rajya Sabha. The Vice President can be removed by a resolution of the Rajya Sabha passed by effective majority and agreed to by Lok Sabha by simple majority. True. The then majority in the Rajya Sabha and then accepted by the members present and voting in the Lok Sabha. The Constitution prescribes specific grounds for the removals. There is no specific grounds for the removal. The specific grounds for the removal is only for the President, that is on the grounds of violation of the Constitution. Statement 3 is wrong. So what is the right answer? 1 and 2 only is the right. Which of the following statement is correct regarding the President of India? The President administers the oath of office to the leader of opposition is correct. So this is not the right thing. The President does not administer such oath. The President submits his resignation to the Chief Justice. No. The President holds office for 5 years from the date he enters upon the office. So this is definitely true. Option C is correct. The President can dissolve the Rajya Sabha. Rajya Sabha is a permanent house. Nothing can be dissolved. So the right answer is option C. Come to question number 9. With reference to the powers of the President of India, consider the following statements. The President can pardon a death sentence awarded under the state law. So yes, that can be done. The President can promulgate ordinances even when both the houses of the Parliament is in session. No, that is not possible. The President lays the report of the Comptroller and Auditor General before Parliament. The President lays the report of the Comptroller and Auditor General before the Parliament. Yes, that is true. The President can withdraw the money from the Consolidated Fund of India without Parliament authorization in case of national emergency. The President can withdraw the money from the Consolidated Fund of India without parliamentary authorization in case of national emergency. This is not possible. So, anytime, whenever you have to withdraw the money from the Consolidated Fund, it requires authorization of the Parliament. Which of the statements given above are correct? So, the correct statement is 1 and 3 only. That is option A is the right answer. Please come to the next thing. Consider the following statements regarding the President of India. The President can return a money bill for the consideration but must give the assent if it is passed. The President cannot return a money bill for the reconsideration. The President can return an ordinary bill but not a money bill. So that is wrong. The President appoints the Chief Ministers of all the states on the advice of the Prime Minister. No. The Governor appoints the Chief Minister. The President has nothing to do with the Chief Minister. The President may appoint the Chief Minister of the Union Territories, not that of the states. Which of the statements given above are true? It is neither 1 nor 2. Alright. So come to the next thing. Question number 11. The basic structure doctrine restricts the Parliament from altering certain essential features of the Constitution even through a constitutional amendment. This is definitely true. That is exactly what is the doctrine of basic structure. The Supreme Court has held that the Parliament's power to amend the Constitution is unlimited and cannot be questioned by the judiciary. The Supreme Court has held that the Parliament power to amend the Constitution is unlimited and cannot be questioned by judiciaries. There is nothing. It exactly goes against the concept of basic structure. Therefore, the answer is A is true and R is false. Option C is the right answer. Please come to the next question. Which one of the following is regarded by the Supreme Court as a part of the basic structure of the Constitution? Procedure established by law is not the basic structure. Supremacy of the Constitution is the basic structure. Which one of the following is regarded as by the court as a part of basic structure? Judicial supremacy over Parliament? No. Parliamentary form of government only in the Union, not in the states? No. In general, the parliamentary form of democracy is a basic structure. So therefore, the right answer is here is option B. Come to next question. With reference to the procedure for constitutional amendment in India, consider the following statements. A constitutional amendment bill can be introduced in either House of Parliament and does not require prior recommendation from the president. Yes, a constitutional amendment bill can be introduced in the either houses. It does not require a prior recommendation. It can be introduced either by a minister or by a private member. A constitutional amendment bill must be passed in each house by a special majority, that is a majority of the total membership of the house and 2/3 of the members present and voting. A constitutional amendment bill must be passed in each house by a special majority, that is a majority of the total membership of house and 2/3 of members present and voting. Yes, of course, this is also true. All constitutional amendment bill requires approval of at least, no, not all constitutional amendment bills does not require this. Only constitutional amendment bill which is trying to amend the federal features in the constitution. Not all the constitutional amendment bill requires the approval of one of the states. That is wrong. The president is bound to give the assent to the constitutional amendment bills passed duly by the parliament. The president is bound to give the assent. Yes, this is mandatory under the 24th Constitutional Amendment Act in 1971. So what is the answer here? So statement 1, 2 and 4 is correct. So the answer is option B only. Come to the next question. Consider the following statements relating the amending powers of the parliament. The parliament can amend any part of the constitution including the fundamental rights as long as the amendment does not destroy the basic structure. This is true. The only restriction upon the powers of the parliament to amend the constitution is in the form of basic structure. So therefore this is true. The parliament power to amend the constitution under article 368 is subject to judicial review. Yes, on the grounds of what is called as basic structure. No constitutional amendment can be challenged in court of law once it has been approved by the parliament and ratified by the states where it is required. No, it is subject to be challenged on the grounds of basic structure. The limited amending powers to amend the constitution was held to be a basic feature of the constitution. True. The limited amending powers of the parliament was held to be the basic feature in the Minerva Mills case. So this is also true. So what is the answer? Except 3, everything else is right. So the answer is option A, 1, 2 and 4 only. Come to the next thing. With reference to the directive principles of state policy DPSP, consider the following statements. The directive principles are non-justiciable but fundamental in the governance of the country. The directive principles are non-justiciable but fundamental in the governance of the country. That is true. The constitution declares that the state shall strive to promote cottage industries on cooperative basis. This is also true. Uniform civil code for all citizens is classified under the socialistic principle. No, it is a liberal intellectual principles. Promotion of international peace and security are included under the liberal principles. This is true. Except 3, everything else is true. So the answer is option B, 1, 2 and 4 only. Come to the next thing. With reference to the directive principle of state policy, which of the following are correctly matched? DPSP, promotion of international peace, it is liberal principle. Organization of village panchayat, that is Gandhian principle. Equal pay for equal work, that is socialistic principle. Protection and improvement of environment, that is liberal intellectual principle. So the answer is option D. None of the above is correctly matched. Come to the next thing. Which one of the following is not regarded by the Supreme Court as a part of the basic structure? Judicial review is part of the basic structure. Harmony between fundamentals is part of basic structure. Parliamentary form. Procedure established by law is not part of the basic structure. Therefore, the right answer here is, in this case, is option D is the right answer. Come to question number 8. With reference to the majorities required for the constitutional amendment in India, consider the following statements. A constitutional amendment that seeks to change the federal provisions requires approval by not less than half of the state legislature. A constitutional amendment that seeks to change the federal provisions requires approval by not less than half of the state legislature. Yes, this is true. Every constitutional amendment must be passed in each house of the parliament by a majority of the total membership of the house and by a majority of not less than 2/3 of the members present and voting. This is also true. So this is what is the majority that is required. A constitutional amendment that seeks to modify the fundamental rights must be ratified by not at least one. The fundamental rights is not part of the federal feature. Therefore, this is wrong. So which of the statements given above are correct? Statement 1 and 2 only. Come to the next question. With reference to the fundamental duties, consider the following statements. Fundamental duties can be enforced by law made by the parliament even though they themselves are non-justiciable. The fundamental duties are enforced by a law made by the parliament even though they themselves are non-justiciable. The fundamental duties themselves are non-justiciable, but they can be enforced by a way of a law. Yes, the parliament can make a law and they can enforce them. The duty to provide opportunities for education to one's child was added by the 86 Constitutional Amendment Act. This is also true in 2002. Fundamental duties are applicable to all the persons including Indian and foreigners. No, fundamental duties are only to the citizens. It is not to the foreigners. Which of the statements given above are correct? It is option A, that is 1 and 2 only. Come to the next question. Fundamental duties help in promoting the constitutional values and responsible citizenship in India. That is definitely true. The very objective of the fundamental duty is to create responsibilities among the citizenship. Fundamental duties are legally enforceable and can be directly enforced by the courts in the same manner as that of fundamental rights. No, they cannot be directly enforced in the courts. They can be enforced by way of a law, but just because they're in the fundamental duty, they cannot be enforced. So what is the right answer? A is true, but R is false. Option C is the right answer. Please come to question number 21. Which of the following statement is correct regarding the fundamental rights? They are absolute and cannot be restricted. No, they are not absolute. They are qualified in nature. They may be enforced against both state action and private individuals violation in certain cases. Yes. So for example, Article 15 Clause 2, it can be enforced both against the state and the private individuals. Right against untouchability, right against exploitation. So these things can be enforced both against the state as well as the private individuals in certain cases. Therefore, it is right. They cannot be amended by the parliament. No, they can be amended. The suspension requires approval of no. The suspension does not require the approval of the state legislature. So the right answer is option B. B is the right answer. Come to question number 22. Which one of the following writs is issued to restrain a judicial authority from continuing an action that is ultra vires of its powers? So there is a writ under Article 32, and if you look into the writ under Article 32, it is a writ of prohibition that tried to prohibit a particular judicial or a quasi-judicial authority from exceeding its jurisdiction. So therefore, the right answer here is prohibition. Certiorari is quashing the order, mandamus is commanding a particular public authority, and habeas corpus is to produce a body. So therefore, right answer here is option C. Come to next question. Which of the following is included in the definition of state under Article 12? It includes the government of India, the government of the state, the parliament of India, the parliament of the states, the local authorities, and any other authority within the territory of India. So government is there, parliament is there, local authorities, institutions substantially financed by the government, other authorities where an institution substantially financed by the government. So that is also there. Therefore, the right answer is option C. 1, 2, 3, 4, all the things. Which of the following is not treated as law under Article 13? So law under Article 13 means anything that is considered to be law under Article 13 shall not be violative of the fundamental rights. What is considered to be law under Article 13? Laws made by parliament and state legislature, ordinances, subordinate legislations, and then you have what is called as customs having the force of law. So ordinance, yes. Rules and regulation, yes. Constitutional amendment is not a law. Notifications issued under the statutory authority. Which of the following is not a law? So therefore, the answer is option C. A constitutional amendment is not a law. In fact, a specific amendment has been made by the 24th Constitutional Amendment Act 1971, specifying a constitutional amendment not to be a law under Article 13. Come to the next one. Which one of the following writ is issued by the public officer or authority failed to perform the duty legally required? That is mandamus. Mandamus basically means we command. When any of the public authorities fail to perform their duties, which results in the violation of the fundamental right, then the court can issue a command. That is basically what is called as mandamus. With reference to right to freedom of religion in India, consider the following statements. Article 25 guarantees freedom of conscience, right to freely profess, practice, propagate religion. Yes, true. Article 26 gives every religious denomination the right to manage its own affairs in the matters of religion. Yes. Article 26 gives every religious denomination the right to manage their own religious affairs. That is also true. Both Article 25 and Article 26 are subject to reasonable restrictions only on the grounds of public order, morality, and health. So, Article 25 and Article 26 are subject to reasonable restrictions only on grounds of public order, morality, and health. In fact, Article 25 can be reasonably restricted on the grounds of public order, health, morality, and also on the grounds of violation of any of the other fundamental rights, not only on the grounds of public order, health, and morality. So both and the word only makes a little bit of difference. So therefore, this is wrong. So which of the statements given above are correct? So the correct answer is 1 and 2 only. Come to next thing. Which of the following best describes the idea due process of law as understood in India after the Mena Gandhi judgment? Statement A. The state can deprive a person of life or liberty strictly according to the procedure laid down by the legislature. The state can deprive a person of life or personal liberty, strictly in accordance with the procedure laid down by the legislature. So, the Mehta Gandhi case does not talk about the procedure. In fact, it is in the Mehta Gandhi case, the procedure established by law was changed to what is called as due process of law. Procedure established by law must be just fair. It is not procedure established by law, rather it is due process of law. Courts cannot question the reasonableness of a law that deprives the personal liberty. No, the courts have to question. Due process of law applies only during preventive detention and not in ordinary criminal laws. Okay, so let me just go to the question once again. Which of the following best describes the idea of due process of law? I think we'll have to just re-look into it once again. Let me just. The state can deprive a person of the right to life and liberty strictly according to the procedure established by law. So that is not the wrong. That is not the correct. The procedure prescribed by the law must be okay. The procedure prescribed by the law must be just, fair, and reasonable, and not arbitrary or oppressive. That's exactly what is due process of law. Therefore, it is option B is the right answer. Come to the next question. Under Article 19, Class 1, Subclass A, which of the following is not a ground which the state may impose reasonable restrictions on freedom of speech and expression? There are 8 grounds on which the restrictions may be imposed. Under Article 19, Class 1, Subclass A, it may be on the grounds of sovereignty and integrity of India, security of the state, friendly relation with foreign states, public order, and then you have decency or morality, contempt of the court, defamation, incitement to an offense. So, what is not there is promotion of social welfare. So, therefore, the answer is option D. With reference to preventive detention in India, consider the following statements. A person detained under the preventive detention must be informed of the grounds of detention as soon as possible. Yes. Under Article 22 of the Constitution, this is a requirement. The detaining authority is required to provide the detained person an opportunity to make a representation against the orders. The detaining authority is required to provide the detained person an opportunity to make a representation against order. Yes, this is also true. So, he should be given an opportunity, anyone who is detained. The advisory board must confirm the detention within 6 months. No, the advisory board must confirm it within 3 months from the date of detention. So, therefore, the statement 3 is wrong. Which of the statements are correct? Statement 1 and 2 is the correct answer. Please come to the last question. Article 14 permits reasonable classification but prohibits what is called as class legislation. This is very much true. Under the concept of Article 14, there is also what is called as equality before law and equal protection of laws. Equal protection of laws only wants people who are equally placed to be treated equally. Therefore, when people are not equally placed, reasonable classification can be made. So, reasonable classification is a good classification which is sound in law, but whereas class legislation means arbitrary classification. So, this is definitely true. Article 14 permits reasonable classification but not class legislation. Classification under Article 14 to be valid only if it is based on what is called as intelligible differentia and has a reasonable nexus between the object and the law. That is true. So, there is an assertion and the reason is specifically explaining why Article 14 allows for what is called as reasonable classification, not class legislation, because Article 14 only allows the reasonable classification, and something is a reasonable classification only that there is a proper nexus between the classification and the object that the law wishes to achieve. Therefore, it is a correct reason of what is given in the assertion. So, therefore, the answer is option A. So, let us move to the next question. Okay. Let us move to the next question. Which one of the following words were added to the preamble by the 42nd Constitutional Amendment Act? Secular. In fact, 3 words were added: socialist, secular, and the word integrity. The preamble was amended only once by the 42nd Constitutional Amendment Act. The preamble is considered to be the part of the Constitution because the Supreme Court declared it to be part of the part of the Constitution in the Keshavananda Bharati case. Okay, so it is the Supreme Court verdict that made it. Which of the following best reflects the Constitution meaning of the word liberty in the preamble? Absolute freedom. Liberty is not absolute freedom. Freedom guaranteed by the Constitution with reasonable limits imposed by the law. That is definitely true. Only political freedom? No. Only freedom from physical restraints? No. It is basically to develop yourself, but with some reasonable restrictions. So, the answer is option D. What is the concept of rule of law as adopted in the India implies which of the following? All laws must originate from Parliament alone? No. No person shall be subject to any arbitrary action by the state. That's basically what is called as rule of law. Rule of law means law is supreme. No arbitrary action by the state. Executive decision, no. Only elected representatives, no. So the answer is option B. Come to the next thing. Constitutionalism primarily implies which of the following? Constitutionalism primarily implies that a system where the constitution restricts the arbitrary use of power. So constitutionalism, there is a limitation upon the powers of the state. Therefore, there is no arbitrary exercise of power. So the right answer is option B. Assertion and reason type question. India follows a system of cooperative federalism. Yes, assertion is right. The constitution assigns rigid and exclusive legislative powers to the union and the states with no scope for overlap. No, in fact, there's an overlap between the parliament and the state legislature. There's a concurrent list. So therefore, this is wrong. So what is the answer here? A is true, but R is false. The reason is not the correct explanation of the assertion. All right. Which of the following statement is correct regarding the formation of new states in India? A constitutional amendment is mandatory to create a new state. No, not required. The president must appoint the consent of the state legislature concerned before altering its boundaries. Parliament can form a new state by a simple majority after referring the bill to the state legislature for its opinion. True. President need not take the consent. President just have to take the opinion. Constitutional amendment is not required. The Supreme Court must approve the changes. No. So the right answer is option C is the right answer. The scheme of union and its territories under part 1 of the constitution reflects which of the following principles? India is a loose federation where states possess the right to secede. No, the states have no right to secede. The territorial integrity of the state is subordinate to the sovereign power of the parliament to reorganize the union. Yes, because we say that the parliament can unilaterally destroy the states and therefore they can reorganize the union. So that is definitely true. The states have equal constitutional status and therefore cannot be altered. No. Any alteration of state boundaries require a constitutional amendment? No, not necessarily in all the cases. What is the underlying constitutional rationale for granting Parliament the exclusive power to make laws relating to acquisition and termination of citizenship? Citizenship is a matter which requires uniformity across the union. This is definitely true. Citizenship is an item in the union list. And why it has been given in the union list? Because citizenship as a matter requires uniformity throughout the country, and that's the reason it has been given in the union list. All right. Assertion and reason. India does not follow the principle of absolute jus soli. Jus soli means citizenship by birth. India does not follow absolute jus soli. True. Because presently citizenship by birth is decided not only on the basis of birth. A lot of other conditions should also be seen. The Citizenship Act 1955 requires that the citizenship by birth at least one parent of the child must be an Indian citizen and another must not be an illegal migrant at the time of birth of the child. True. Just solely if it is absolute, the only condition should be seen is whether the child is born in the territory of India at the time of the birth of the child, then that condition is sufficient enough. But in addition to that, today a lot of conditions are required. So assertion is exactly supported by the reason. So the answer is option A. A is the right answer. Which of the following best explains the meaning of the democracy as adopted in the Indian Constitution? Government by majority community alone, a system where elected representatives exercise power but remains accountable to the people. The very essence of democracy is that the elected government or the authority remains accountable to the people. The form of government where all the laws are no, a system only the political rights are guaranteed. No, these are all wrong. Which of the following provision ensures the independence of the judiciary in India? Parliament has the power to alter the jurisdiction of the Supreme Court. No, that does not. Judges of the Supreme Court hold office during the pleasure of the President. No. Judges of the Supreme Court can be removed only through a special majority procedure. That's extremely difficult. That gives independence to the judiciary. Salaries of the judges can be reduced by the Parliament. That does not give the independence. Which of the following constitutional provisions illustrate the principle of checks and balances? Checks and balances means how one organ of the state is having control over the other organ. The power of the judicial review of the Supreme Court. Yes, Supreme Court can have the power of judicial review of the legislature and executive. Checks and balance. The power of the parliament to impeach the president. Yes, checks and balance. Legislature upon the executive. The power of the judiciary to review the constitutional amendments. Yes, power of the judiciary over again the legislature. So what is the correct answer here? Option D. That is all the three. 1, 2 and 3 is the right answer. Indian federalism is often described as quasi-federalism with a strong unitary bias where it is more power given to the union. States have constitutional right to secede under a national emergency. No. Parliament has the power to alter the boundaries without requiring the consent. Yes. More power to the union legislature in comparison to that of the states. Only union list is binding. State list is merely recommendatory. No. India does not have a written constitution, no. So the right answer is option B. So option B gives more power to the parliament vis-a-vis the states. A key feature of parliamentary democracy in India is what? The executives are collectively responsible to the lower house. That is what is very important. The key feature of the parliamentary system itself is the executives are collectively accountable to the legislature. With reference to the Constituent Assembly of India, consider the following statements. The members of the Constituent Assembly were partly elected and partly nominated. Yes. From the princely states they were nominated, and from the provinces they were elected indirectly. The Assembly adopted the Constitution on 26 November 1949 but continued to function as a provincial parliament of India until its first general election. Yes, the first general election came only in 1951-52. Until the time, the Constituent Assembly continued as a provincial parliament. The idea of Constituent Assembly for India was first suggested by the British Cabinet Mission Plan. So, it was not suggested by the British Cabinet Mission Plan, but rather it was by whom? Rather it was by M. and Roy in 1934. So, therefore, this is wrong. So, which of the statements given above are correct? It is 1 and 2 only. The Government of India Act 1919, the Government of India Act 1909 is significant because for what reason the Government of India Act 1909 is significant? If you see, so rather I would say it should not be the Government of India Act 1909. It should be the Indian Council Act. Okay, I'm just making a small change. It's not the Government of India Act, it is the Indian Councils Act. Okay, so let us make this as Councils Act. The Councils Act 1919 is significant for it introduced direct elections for the first time. No, it did not introduce. It introduced separate electorate for the Muslims. Yes, that is true. That is the reason Lord Minto came to be the father of communal electorate in our country. Gave provincial autonomy, no. Granted dominion status, no. So provincial autonomy came only in 1935, and dominion status was granted only by the Indian Independence Act. So right answer is option B. Which of the following provisions were introduced by the Charter Act of 1833? It ended the East India Company's commercial function. This is definitely true. It introduced federal features. No. It introduced open competitive system. No. None is also no. So the right answer is option A. So these are all important areas where you can expect one question. Which of the following features are introduced by the Government of India Act 1935? If you see Government of India Act 1935, they introduced diarchy in provinces is wrong. It is in 1919. Provincial autonomy was a major feature. Separate electorate for Muslims is wrong. This is also wrong. So the answer is option B is the right answer. Come to the last thing. Which of the following is not a major provision of the Government of India Act 1919? Introduction of not a major provision. That introduction of bicameralism in center is true. Introduction of diarchy in the province is also true. Introduction of direct election is also true. So the right answer is option D. None. D is the right answer. That is not a provision of the Government of India Act 1919. So with that we are coming to the end of the discussion for day 7, 50 questions from polity. So further in the next week also we will continue with the polity discussion, and in couple of weeks the polity discussion will be done. Then we will start with what is modern history. So this is for the batch 1, but the batch 2 is likely to commence from 15th of December, and the students who wanted to have a proper plan, and if they want to prepare on a daily basis and to revise on a daily basis and to take regular tests and to have discussions and to solve their doubts with the mentors, you can reach out to us and you can be part of this particular program. And I'm very sure this program is going to be immensely successful for the students preparing for 2026. All right. Thank you very much for watching this particular video, and all the very best.